Should I put my house or bank accounts in my kids' names?
So often when people are trying to protect assets from Medicaid, they think about putting the house or putting bank accounts into a child's name. And almost in every circumstance, that's not a good idea if we're planning ahead. Now, if we're in a crisis situation, sometimes that's exactly what we will do, is we will go ahead and use a particular type of deed to protect the real estate to make sure that it's not subject to Medicaid estate recovery, that Medicaid can't get a lien on that and force the sale later on. But when we're planning ahead, generally we don't want to put assets into a child's name. And there's a number of reasons for doing that. I've seen so many horror stories that when it has been done, somebody else has done that, come in and told me about it, and they say, how can we fix this? So many horror stories that I just know. What happens if the child becomes disabled? What happens if the child dies? What happens if the child has debts? What happens if the child divorces? Over 50% of marriages end in divorce now. And when you put your real estate, your home place, into your child's name, you're not only making a gift to that child, you're also making a gift to your son-in-law or daughter-in-law. And how many people have in-laws that they think of as outlaws? Well, in that circumstance, when you've added a child's name onto the deed and you later want that property back, or you want to sell that property, or if that child goes through a divorce, there are all kinds of bad things that can happen if you don't have the cooperation of both your son and your daughter-in-law or your daughter and son-in-law.